Labo v. Kumlik. Facts: Ramon Labo, Jr. married an Australian citizen in the Philippines. He was granted Australian citizenship in 1976. In 1980, the marriage was declared void for being bigamous. Labo returned to the Philippines in 1980, using an Australian passport, and obtained an alien certificate of registration. He later applied for a change in status from immigrant to returning Filipino citizen. However, the Commission on Immigration and Deportation denied his application for the cancellation of his ACR since he has not applied for reacquisition of his Filipino citizenship. According to the records of the Australian Embassy, Labo was still an Australian citizen as of April 12, 1984. Although no direct evidence was presented to prove that he took an oath of allegiance as a naturalised Australian citizen. The laws of Australia at the time required any person over the age of 16 years who is granted Australian citizenship to take an oath of allegiance. The wording/text of this oath includes a renunciation of all other allegiance. Labo ran and won as mayor of Baguio City in the local elections held on January 18, 1988. The second placer, Luis Lardizabal, filed a petition for quo warranto, alleging that Labo is disqualified from holding public office on the grounds of alienage, and asking that the latter's proclamation as mayor be annulled. Issues: The original issue raised before the Supreme Court concerned only the Kumlik's jurisdiction over Lardizabal's petition. Labo contended that the petition for quo warranto was not filed on time. Hence the Kumlik lacks the jurisdiction to conduct an inquiry regarding his citizenship. However, the SC decided to rule on the merits of the case, given that the issue is also of considerable importance, and in the interest of the speedy administration of justice. Does the Kumlik have the jurisdiction to inquire into Labo's citizenship? Is Ramon Labo, Jr. a Filipino citizen? Is he qualified to hold public office in the Philippines? If Labo is not eligible to serve as mayor, can Lardizabal, as the runner-up in the elections, replace him? Held/ratio. Yes. Contrary to Labo's claim, the petition for quo warranto was filed on time. Lardizabal did not immediately pay the filing fee because the Kumlik had at first considered the petition as a pre-proclamation proceeding, which does not require the payment of such a fee. When the Kumlik reclassified the petition, Lardizabal immediately paid the filing fee. Thus, he still complied with the prescribed 10-day period. Furthermore, the court held that such technicalities should not hinder judicial decisions on significant issues, such as the one being decided in this case. Labo is not a Filipino citizen. He had lost his Philippine citizenship by all three modes specified in the Constitution: naturalization in a foreign country, express renunciation of citizenship, and subscribing to an oath of allegiance to support the Constitution or laws of a foreign country. He has not reacquired Philippine citizenship by any of the three methods prescribed in the Constitution: direct act of Congress, naturalization, and repatriation. Contrary to Labo's claim, his naturalization in Australia did not confer him with dual citizenship. The Constitution explicitly states that dual citizenship is inimical to national interest. The contention that his marriage to an Australian national did not automatically divest him of Filipino citizenship is irrelevant. There was no claim that Labo had automatically ceased to be a Filipino because of that marriage. Also, his Filipino citizenship has not been automatically restored upon the annulment of his Australian citizenship, when his marriage was declared void on the grounds of bigamy. The Commission on Immigration and Deportation held in 1988 that Labo was not a Filipino citizen. The earlier contrary decision by the Kumlik in 1982 is totally baseless, and is even alleged to have been politically motivated. The latter can be reversed because the doctrine of residential judicata does not apply to questions of citizenship. Labo is not eligible to hold public office in the Philippines. He was not even a qualified voter when he was elected. Despite getting the second highest number of votes, Lord Isabelle cannot assume the position of mayor because he has not been duly elected by the people of Baguio City. Labo's disqualification alone does not entitle him to take office. Instead, the elected vice mayor shall replace Labo. Separate concurring opinion. Although no decision has been rendered by the Cumlic and elevated to the SC for review, it is undeniable that a foreigner cannot be allowed to hold public office in the Philippines. It is regrettable, however, that Labo should be disqualified on the basis of his citizenship because he has already achieved a lot while serving as mayor during the pendency of the case. Frivaldo v. Cumlic. Facts. Petitioner Juan G. Frivaldo was proclaimed governor-elect and assumed office in due time. The League of Municipalities filed with the Cumlic a petition for annulment of Frivaldo's election and proclamation on the ground that he was not a Filipino citizen, having been naturalized in the United States. Frivaldo admitted the allegation but pleaded the special and affirmative defenses that his naturalization was merely forced upon himself as a means of survival against the unrelenting prosecution by the martial law dictator's agent abroad. Issue: whether or not Frivaldo was a citizen of the Philippines at the time of his election. Held no. Section 117 of the Omnibus Election Code provides that a qualified voter must be, among other qualifications, a citizen of the Philippines, this being an indispensable requirement for suffrage under Article V, Section 1, of the Constitution. Even if he did lose his naturalized American citizenship, such forfeiture did not and could not have the effect of automatically restoring his citizenship in the Philippines that he had earlier renounced. Qualifications for public office are continuing requirements and must be possessed not only at the time of appointment or election or assumption of office but during the officer's entire tenure. Frivaldo declared not a citizen of the Philippines and therefore disqualified from serving as a governor of the province of Sorsogon. In the certificate of candidacy he filed, Frivaldo described himself as a natural-born citizen of the Philippines, omitting mention of any subsequent loss of such status. The evidence shows, however, that he was naturalized as a citizen of the United States in 1983 per the following certification from the United States District Court, Northern District of California. As duly authenticated by Vice Consul Amado P. Cortez of the Philippine Consulate General in San Francisco, California, USA. This evidence is not denied by the petitioner. In fact, he expressly admitted it in his answer. Nevertheless, as earlier noted, he claims it was forced on him as a measure of protection from the persecution of the Marcos government through his agents in the United States. The court sees no reason not to believe that the petitioner was one of the enemies of the Marcos dictatorship. Even so, it cannot agree that as a consequence thereof he was coerced into embracing American citizenship. His feeble suggestion that his naturalization was not the result of his own free and voluntary choice is totally unacceptable and must be rejected outright. There were many other Filipinos in the United States similarly situated as Frivaldo, and some of them subject to greater risk than he, who did not find it necessary nor do they claim to have been coerced to abandon their cherished status as Filipinos. They did not take the oath of allegiance to the United States, unlike the petitioner who solemnly declared on oath, that I absolutely and entirely renounce and abjure all allegiance and fidelity to any foreign prince, potentate, state or sovereignty of whom or which I have heretofore been a subject or citizen, meaning in his case the Republic of the Philippines. The martyred Ninoy Aquino heads the impressive list of those Filipinos in exile who, unlike the petitioner, held fast to their Philippine citizenship despite the perils of their resistance to the Marcos regime. The Nate Bohm case cited by the petitioner invoked the international law principle of effective nationality, which is clearly not applicable to the case at bar. That case is not relevant to the petition before us because it dealt with a conflict between the nationality laws of two states as decided by a third state. No third state is involved in the case at bar. In fact, even the United States is not actively claiming Frivaldo as its national. The sole question presented to us is whether or not Frivaldo is a citizen of the Philippines under our own laws, regardless of other nationality laws. We can decide this question alone as sovereign of our own territory, conformably to Section 1 of the said convention, providing that it is for each state to determine under its law who are its nationals. It is also worth noting that Nottebohm was invoking his naturalization in Liechtenstein, whereas in the present case Frivaldo is rejecting his naturalization in the United States. If he really wanted to disavow his American citizenship and reacquire Philippine citizenship, the petitioner should have done so in accordance with the laws of our country. Under CA number 63 as amended by CA number 473 and PD number 725, Philippine citizenship may be reacquired by direct act of Congress, by naturalization, or by repatriation. It does not appear that Frivaldo has taken these categorical acts. He contends that by simply filing his certificate of candidacy he had, without more, already effectively recovered Philippine citizenship. But that is hardly the formal declaration the law envisions. Surely, Philippine citizenship previously disowned is not that cheaply recovered. If the special committee had not yet been convened, what that meant simply was that the petitioner had to wait until this was done, or seek naturalization by legislative or judicial proceedings. Gutierrez Jr. Concurring. I concur in the pragmatic approach taken by the court. I agree that when the higher interests of the state are involved, the public good should supersede any procedural infinities which may affect a petition filed with the Commission on Elections. I fail to see how the court could allow a person who by his own admissions is indubitably an alien to continue holding the office of governor of any province. It is an established rule of long standing that the period fixed by law for the filing of a protest, whether quo warranto or election contest, is mandatory and jurisdictional. As a rule, the quo warranto petition seeking to annul the petitioner's election and proclamation should have been filed with 10 days after the proclamation of election results. The purpose of the law in not allowing the filing of protests beyond the period fixed by law is to have a certain and definite time within which petitions against the results of an election should be filed, and to provide summary proceedings for the settlement of such disputes. The rules of court allow the Republic of the Philippines to file quo warranto proceedings against any public officer who performs an act which works a forfeiture of his office. However, where the Solicitor General or the President feel that there are no good reasons to commence quo warranto proceedings, the court should allow a person like Istuyi or his league to bring the action. I must emphasize, however, that my concurrence is limited to a clear case of an alien holding an elective public office, and perhaps in a clear case of disloyalty to the Republic of the Philippines. Where the disqualification is based on age, residence, or any of the many grounds for ineligibility, I believe that the 10-day period should be applied strictly. The pragmatic approach is also shown by the fact that the court found it inexpedient to wait for the final decision of Cumlic. This step is most unusual, but considering the total lack of any serious grounds for the petitioner's claim of having regained his Philippine citizenship, I am constrained to concur in the procedure pro hac vice.